This week I want to talk to you about how to hold title on your house in a deed of trust, and I want to talk to you about that right now. Common forms of residential ownership. Ownership of real property can be owned by a sole owner, or it may be owned by two or more persons. Concurrent ownership or co-ownership means simultaneous ownership of a given piece of property by two or more persons. Common types of concurrent residential ownership are tenancy in common, joint tenancy, community property, and community property with the right of survivorship. That's the way most people are taking title now, is community property with right of survivorship. Okay, but let's explain the tenancy in common. It's characterized by only one unity, that of possession. It is created whenever an instrument conveys an interest in real property to one or more persons and specifies tenancy in common. If a recorded conveyance document does not expressly specify the tenancy, joint tenancy, community property, etc., the legal presumption is that the vesting is tenancy in common. Interest may be any fraction of the whole. Thus, one party may own 1/10, another 3/10, and a third party may own the remaining 3/5. There is no right of survivorship. Each tenant owns an interest that vests in his or her heirs or devices upon death. That's kind of so. When one dies, the other one has to refinance a house, I guess, and pay off the 3/10 or the 1/10, or just have the survivors move in and live in their 1/10 of the house. Anyway, joint tenancy exists when two or more persons are joint and equal owners of the same undivided interest in specified property. The main characteristics of joint tenancy is the right of survivorship. When a tenant dies, his or her interest in the property is terminated, and the estate continues in the survivor or survivors. The usual method of creation of joint tenancy is by deed describing the grantee as follows: to A and B as joint tenants. The words "with right of survivorship" are often added, but are not a requisite, since the right is an incident of the joint tenancy, whether expressly recited or not. Problems have frequently arisen regarding the true character of the ownership of property by husband and wife as joint tenants. Frequently, such property, despite the status of joint tenancy ownership, has been treated as community property for purposes of succession, transfer, disposition in divorce, or seizure by creditors. It may be shown that property taken in joint tenancy was thereafter converted into community property by written agreement. The contention that joint tenancy property is in fact community property is often raised in divorce cases. The court does not have the power to make an award of separate property, but if it is established that joint tenancy property is in fact community property, the court may award such property to a spouse. Upon the death of one joint tenant, the title automatically passes to the survivor. Title insurance companies will require some formal procedure before recognizing the new owner. Two of the methods are filing an affidavit of death of joint tenant or obtaining a court decree of death of a joint tenant. Certified death certificate's good. Community property is a creation of the civil law of Rome and came to California via Mexico, when the Treaty of Guadalupe Hidalgo provided the property rights of Mexican subjects would be kept inviolate. Early Californians felt compelled to continue the community property system, and it was incorporated into the California Constitution. In general, community property represents the earnings and accumulations of the marriage. Persons who are not married to each other or are not registered domestic partners cannot hold community property together. All property of married persons that is not their community property is the separate property of one or the other. Separate property consists of property owned before marriage, proceeds of separate property such as dividends, rents, profits, or property received in exchange for separate property, gifts and inheritances received after marriage, property agreed between the spouses to be separate property, the earnings of one spouse when living separate from the other spouse. All deeds conveying community property must be signed by both spouses. Community property with right of survivorship. Now, folks, this is the most popular one. This is the one the president of the Halstead team, Norma Halstead, and I hold our property in. Community property with the right of survivorship is a form of vesting title to property owned by husband and wife, same-sex spouses, or registered domestic partners. It shares many of the characteristics of community property, but adds the benefit of right of survivorship similar to title held in joint tenancy. There may be tax benefits for holding title in this manner. On the death of an owner, the decedent's interest ends and the survivor owns the property. All right. Disclaimer, I'm not an attorney. This is my understanding of the popular ways to hold title. Okay? Most people are going with community property with the right of survivorship. As a realtor in the Central Valley of California, this is what I know about California. I don't know about all the other states' laws and everything like that. Maybe get with your trusted real estate advisor and talk about it with them. But if you don't understand any of the ways to hold title, once you're told by your realtor or the title company, and you read through it and you're like, okay, I don't know which one to do, talk to a lawyer. Those are going to be the ones the people you want to talk to. You want to talk to an attorney, let them know all your circumstances. Your attorney will advise you with the best thing for you to do. All right. Thank you very much. I hope you have a great day.